GS score,
GS score, GS score,
GS score,
GS score,
GS score,
GS score, GS score,
GS score,
GS score,
GS score है, GS score,
GS score,
GS score,
GS score,
GS score,
GS score.
GS score.
Hello guys, welcome to GS Score. In this video, I will be discussing with you another most important topic about CLD, and out of CLD, that is about the competition law. Actually, lot of UPSC aspirants who have opted for law optional, they face the biggest dilemma with respect to this competition law or CLD specifically. Out of CLD, competition law, arbitration, environmental law, they find difficulty. So what topics, or some make a biggest mistake, they start reading the entire subject. Please mind it guys, it is not about entire competition law, it is contemporary legal developments. Contemporary. So your main focus should be upon the contemporary part. What is contemporary? So in this question to concept, the unique initiative of GS Score, whereby we teach by analyzing the previous year questions, we teach the concept, and then we let you know the expected questions for the mains examination as well. So in this video, I will be discussing with you, I am just going to show you the question first, and then the current context in which this topic is relevant for all of you. So in 2022, there was a question, what do you mean by abuse of dominance and abusive conduct prohibited under the Competition Act? Actually, this question came in 2022 because there was a judgment of Competition Commission of India against Google, and Google was misusing its dominant position, and Google was into the anti-competitive agreements as well. So this was about the application of section 4, and this was about the application of section 3, and Google was penalized in violation of section 3 and section 4 with respect to its Android platform given for the mobile phones. And that was the reason this question came in 2022. Similarly, in 2020, there was the question about IPR and its relation with the competition law. This question came in the context of TRIPS. Actually, at the time, the discussion was going on that the COVID vaccine made by the pharma companies of America and the UK and other European countries, they should not be given any protection, the protection given through the Patent Act. So no protection should be given, because and the compulsory licensing should be allowed to protect the lives of the persons due to COVID issue. So there was a lot of discussion at that moment of time that the protection granted with respect to patent under the TRIPS for 20 years should not be given for the COVID vaccines and the medicines, etc., so that the lives of the million of peoples can be saved. But fortunately, there was no requirement of that nonsense, because ultimately what is happening with those medicines now we came to know. So anyhow, now the point is, what is the current context? Actually, recently government has come out with one new kind of thing. No doubt this concept was there earlier as well, but now government has modified that concept, and they have introduced one proactive approach to manage the cartels. Cartels basically fall under the ambit of section 3, the anti-competitive agreements. So in anti-competitive agreement, there is a concept of, you can say, cartels, and what is the latest amendment in that regard is, it is about CCI, Competition Commission of India's lesser penalty plus concept. So generally this is now known as LPP concept, lesser penalty plus concept. So what is this concept and how it is relevant for all of you in this regard? I give an example. If you see the previous year questions, so whenever there was any contemporary advancement in that particular field, at the same time you have seen questions in the mains examination. So this time two things have changed in or two things have been updated in this competition law domain. One is latest amendments have taken place in competition act. So what you can do, you can prepare for the amendments as well, prepare one notes evaluation of the amendments made in the competition act, or you can focus upon this concept as well. So they might not be asking you a direct question from this topic, but indirectly they might be asking you a question like, see, the competition act is designed to prevent cartels, to maintain healthy competition, elucidate. So this kind of question they can ask you. So if they are specifically asking you about the word cartels, in that case, obviously you should be mentioning this particular concept. So in competition law domain, two major things have taken place. One is few amendments and second is this one. And how this is going to be beneficial in cartel things that I will discuss with you. So how to approach with respect to such kind of questions, I will tell you. So what is the concept actually? What is this present concept? So you please, just note down. Basically, under section 3, which is about anti-competitive agreements, this section has been amended by the government through the amendments. And anti-competitive agreement, they talk about the thing called cartels. Cartel means when the players operating in the same domain, either vertically or horizontally, when they come together and when they try to manipulate the prices. So basically cartels, they come into picture for the purpose of price fixing, bid rigging, or market sharing, or supply limitation, or supply restrictions, you can say. So basically cartels are created for the purpose of preventing the competition, healthy competition. Like for example, in case of pharma companies or the pharmaceuticals or the chemist, you can say, earlier you should have seen that pharmacists or the chemist, they did not give the discounts. They were not used to give the discounts. They generally give the medicines at MRP, because there were a case in which the pharmacists, they have entered into an agreement with the all other pharmaceutical these chemists, that no one will be offering any discount to any customer. And at that moment of time, it is a case of, you can say, 15 years ago this case happened. So at that moment of time, these pharmacists, they were not giving even a single penny discount to anyone, because there was a cartel among them. And if any chemist used to give discount, though they used to boycott that particular chemist. So this case went before the CCI and it was found that yes, they were into a cartel. Same thing happened with the cement manufacturing companies. Same thing happened with the cylinder manufacturing companies. So basically what we have seen in the past, there were a lot of cases in which companies or the enterprises or the persons, they used to enter into a secret kind of agreement to form a cartel, whereby they used to maintain a kind of relationship by which they did not pass on the benefits of the market power, the bargaining power of the market, demand and supply power, to the consumers. So they used to regulate the prices with their mutual agreement. So what happened basically, this matter, when came to knowledge of CCI, they started investigation through the DG. Then the matter was taken care of. But the biggest issue is these things happens in secrecy. So that is lot of it is very difficult to figure out you know whether this was really happening or not. So, and we have to figure out through the lot of financial factors, other management factors, through which we come to know that yes, there was a case of cartel or not. In this regard, now CCI, or you can say the Government Competition Act, sections 46 has been amended in this dimension, so that a kind of new a kind of incentive has been offered to the whistleblowers, that if any person or any enterprise who was into the cartel, if that person makes a disclosure as a whistleblower to the Competition Commission of India in advance, that sir, this is going on, this kind of cartel kind of thing is going on. If that person makes a kind of publication before the authorities and cooperates with the authorities, then he will be given a lenient treatment. He will not be penalized. He will be given discount in the penalty. So basically, the concept of this, what we can say, lesser penalty plus regulation, these regulations have been made by the government of India in 2024. Before that, there was a concept of minor penalty plus 2023, and actually this started through lesser penalty regulation 2009, which were amended in 2017 as well. So these were amended in 2017. Then latest one were in 2023, but now the latest totally updated one, now we have been given lesser penalty plus 2024 regulations, in which the main purpose of these regulations is to create a kind of system of, you can say, cartel whistleblower. So if that cartel whistleblower gives the information about any cartel, so earlier what used to happen, I tell you, what is the concept actually. So earlier what used to happen, if this cartel whistleblower is providing the information that is proactive disclosure, then substantial assistance, then cooperation throughout this entire proceeding, and no destruction of evidence. If these things are there, and another point is there are 5 conditions: ceased to participate in cartel. So if that whistleblower makes a proactive disclosure and provides substantial assistance to the authorities and cooperate with them at every level, and ceased to participate in the cartel and no destruction of evidences, then he will be given 100% reduction in the penalty. Then he will not be subject to the penalty. So if any person who appears for the first time, the first applicant, he will be given 100% waiver. If subsequently any person comes after that, then he will be given 50% reduction in penalty, and subsequent persons will be given 30% reduction in penalty. In competition law, there is no criminal penalty actually. Only civil kind of like this solution is there. So basically, penalty in terms of money is there. So if any enterprise or enterprises or persons, if they enter into the cartels, they will be given penalty. They will be subject to penalty, which will be based upon their turnover. Now the point is, if you come before the authorities as a whistleblower, then you will be getting a reduction in the penalty. If you come first, 100% reduction. Second, if you come second at second point of time or subsequent, means if A comes first by saying that there is a cartel, B comes second, and C and D comes later on, then there will be a reduction of penalty like this only. So what is this new concept, lesser penalty plus concept? It is actually an extension of this thing. What is this extension, guys? The extension is, now in the lesser penalty plus concept, the new concept is, if any cartel whistleblower gives any information about the cartel to the government, to the CCI, and if there was any initial investigation was going on against that person, against that enterprise, then he will be getting benefits in two ways. One benefit is he will be given 100% waiver of penalty in you can say in the present reporting. So the present case which he has reported, he will be given 100% waiver, 100% waiver. Okay. And if there was any earlier case, he will be subject to additional reduction of 30%, up to 30% of fine in a matter under investigation. So this is the way he will be given this kind of like benefit. So this is a kind of, you can say, incentive offered to the person who was a part of the cartel or who is a part of the cartel. So suppose if a person or enterprise enters into a cartel arrangement with other companies, with other enterprises, and if any person as a whistleblower reports that matter, and if that matter proves to be a case of cartel, then ultimately that whistleblower will be subject to the 100% waiver of the penalty, and other persons will be subject to the penalty. So this is a kind of incentive so that matters will be reported on time, so that there won't be serious impact upon the competition. So this is one of the things which has taken place right now. Now the point is how this is relevant for all of you, or what kind of question you should be preparing actually. So if you see, guys, the Competition Act is designed to prevent cartels, to maintain healthy competition. So how to approach for this answer writing? First, before explaining cartel, you should explain the purpose of Competition Act. In every question of Competition Act, I advise you should specifically mention purpose of Competition Act, which means maintain healthy competition. Because the balance, the benefit of healthy competition goes to the customer actually. Then explain anti-competitive agreement given under section 3 of this act, and then explain the elements of anti-competitive agreements. For detailed discussion about anti-competitive agreements, you can watch my another video on our gsscore YouTube channel for better clarity. Then focus upon the cartels, give few examples, and then come to the solution. In solution, focus upon this lesser penalty plus provision, which is given under section 46, now amended in 2024, in which 100%, 50%, 30% to the persons coming at first, second, and third and fourth position, and a person who has reported the matter first, he will be given 100% waiver in the present case and additional 30% in the already going case in which he was a part of the cartel. So like this, you just explain and just conclude that how this kind of strategy is beneficial. Actually, this is the strategy used by the other countries as well to regulate the cartel creation and to incentivize the persons who are a part of the cartels, so that you know cartel should not be created. So this is the way you can appear this kind of, you can attempt this kind of question. But remember one thing guys, by looking at this present scenario, I expect this year, because last year in 2023 there was no question from competition law, so this year in 2024 they are definitely going to ask you question from competition law, so be prepared for this. Thank you guys, thank you very much.